It has been a long and somewhat difficult day, and I am using a filter, sitting in a parking lot, waiting for my son to be done with baseball practice because my husband is in a mediation, which is rude. Um, and I wanted to tie up this one loose end on retaliation. So, if you haven't seen it, I've got a playlist of retaliation elements and it goes through all the different elements of retaliation. But Lively has a separate claim in her complaint for breach of contract, for retaliation through breach of contract. And it is unusual, and I've never seen it before in this context. And I've been trying to figure out what to do with it for about 7 months, and I still don't really know. But I'm going to try to explain to you guys what it is and how it's different so that we can fully understand how it does and doesn't relate to the other retaliation claim. So, first, when it comes to the 17-point list that ultimately becomes the rider to the contract, which is what we're going to be talking about here, you have to split yourself in two. Part of that we've been talking about, and I talk about it in I think 2 videos in that playlist, is could either one of those documents be considered protected activity? That is one of the elements for her to prove retaliation under Title VII and the California EEO law. That is not what we're talking about today. What we're talking about today is, did Wayfarer violate a non-retaliation provision of a contract in a standalone, separate breach of contract claim? So the biggest benefit to Lively of this particular claim is that she doesn't have to prove that she engaged in protected activity in order to win it. Because on the Title VII and FEHA retaliation claims, you have the elements: protected activity, adverse action, and a connection between the two. Here, the obligation not to retaliate doesn't arise from the protected activity, it arises from a contract. And Wayfarer signed that contract, and Wayfarer is bound by that contract where they said they wouldn't retaliate. So even if she can't prove that she complained on set about discrimination or potential discrimination, this claim still lives. And that's why I think it's important that we go through it separately. So all contract claims are basically the same, okay? Existence of a valid contract, the plaintiff performed or substantially performed their obligations, the defendant did not perform their obligations and therefore materially breached the contract, and that material breach caused the plaintiff damages. So that's the elements of a breach of contract claim writ large, whether it's an employment contract, a construction contract, a cell phone contract, any kind of contract, okay? So let's just assume, for the sake of argument, that we have a valid contract here. We have a meeting of the minds. We have offer, acceptance, consideration. There is an argument about whether she really had an employment contract and whether that affects this, but we're not going to get into that in this video. Let's assume that there was a valid contract and that rider is it. And let's presume that she, Blake, performed all of her obligations under the agreement. So the question becomes, did Wayfarer breach and fail to comply with an obligation it had under the agreement? So here's the actual claim in her amended complaint, talking about Wayfarer, and she kind of tries to get it for all of them, whatever, that's a whole nother argument for another day. And she specifically talks about paragraph 10. Paragraph 10 strictly prohibited this company from retaliation of any kind, okay? So again, not all retaliation is prohibited by law. Retaliation is prohibited by law when an obligation not to retaliate is created by someone's conduct. And that can be complaining about discrimination, or it can be just agreeing not to retaliate in a contract. So what we're talking about here is this paragraph that says that essentially Wayfarer, and it ends with us, LLC, there shall be no retaliation of any kind against artists, that's Blakel, for raising concerns about the conduct described in this letter or for these requirements. So what she is saying is, we bargained for and they accepted and signed a prohibition on retaliating against me because we had to make this rider happen in the first place. They can't hold that against me. That in and of itself is a violation of this very agreement. But the first question that Wayfarer is going to answer is, if you're going to enforce a contract term against me, You're going to say I engaged in behavior that is prohibited by this contract. Was it clear to me what was prohibited? Was it clear to me what obligation I supposedly breached? Now, usually, non-retaliation provisions like this arise in settlement agreements. They happen a lot in employee settlement agreements, where let's just say that you go to your boss and say, you haven't paid me my overtime, and you raise a wage and hour claim, and you work it out, and the boss says, okay, or the company says, we're going to pay you back wages, and we're going to give you some extra vacation time. So you have a dispute, you enter into an agreement to settle that dispute, and as part of that, just like you might include like a non-disparagement clause in a settlement agreement that says you won't talk shit about me because we got into this dispute, sometimes people also say, you also won't hold it against me that I raise these claims to you, right? This doesn't prohibit me from getting a promotion down the line or getting a better job or whatever. Which begs the question of, is this document a settlement agreement? And as I've said before, I think part of it seems like it is and part of it seems like it isn't. But could Wayfair tell what was prohibited here? And that's where it gets interesting. So sometimes claims like this will come in front of a judge. It's usually a state court judge because breach of contract is usually a state court claim. And the judge will say there was no definition of what retaliation is, right? It'll just say the first sentence and that's it. And sometimes the judge will say, well, how could the defendant know what was and wasn't allowed? It never defined retaliation. It prohibited something and then never defined it, and that's too vague. It's unenforceable. That's not what happened here, but I don't think it's not vague, okay? So they do define what retaliation would look like as a breach of this agreement. Any changes in attitude, presumably also changes in latitude, sarcasm, I would fail, marginalization, or other negative behavior. That's pretty broad. Negative according to whom? On-set or otherwise, including during publicity and promotional work. So that's how they define retaliation. It's not nothing, but it's not clear. If a contract term is not clear, that doesn't necessarily mean that the court will just throw it out and say this is unenforceable, but it may mean that they allow evidence in, it's called parole evidence, about what the circumstances were when this contract term was created and what everybody thought it meant. I also see questions about, when does this end? Because it does include publicity and promotional work, but at what point does this contract term over? It can't go on forever, right? It's also interesting that it says any of these happening, blah, 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 is retaliatory and unacceptable and be met with immediate action. Well, clearly then there weren't any, at least for the first 6 months, because it is undisputed by everybody, including Lively, that once they signed this, the rest of the movie filming went A-okay. So is it vague? Does it make sense? Is it enforceable? There's other arguments like, is this an adhesion contract, which is a contract basically where you don't get to bargain. It's a take it or leave it. I mean, we all sign them every day, right? It's a take it or leave it. Do you want this cell phone? Sign this thing. Do you want to buy this car? Sign this thing. They don't necessarily always get thrown out, but courts do look at them with skepticism if the person who signed it didn't have a chance, or who it's being enforced against didn't have a chance to bargain for it. And then there's the original question of, is this thing a settlement agreement? And that matters for a lot of reasons, not the least of which is that a settlement agreement and discussions surrounding a settlement agreement are not admissible in court to prove liability. So that changes the whole character of how this thing could actually be presented for trial. And if you look at the beginning of this, settlement agreements always say, there's a dispute, we've decided to resolve the dispute, here's what the terms are. That's not what this says. It says the parties wish to confirm the conditions under which lender has agreed to cause artists. So in other words, these are the things that we want if we come back to work. That looks pretty one-sided to me. So we're making contract arguments, not EEO arguments. All right, my brain hurts. Let me know what questions you have about this one, and then I'm done with retaliation claims, elements, what.